Now I'm thrilled to kick off the 6th annual review with our Session 1 panel on bid protest. Our distinguished panel members are Jay Carey, a partner in Covington and Burlington Government Contract Practice. Dan Foreman is the co-chair of Crowell & Mooring's Government Contracts Group. Amy Lauteberg O'Sullivan is a partner in Crowell & Mooring and a member of the steering committee for the firm's Government Contracts Group. Craig Holman, chair of the Government Contracts and National Security Practices. Kevin Mullen is the co-chair of Morrison & Foerster's Government Contracts and Public Procurement Practice. And last but certainly not least is Rich Rector, who chairs DLA Piper's Government Contracts Practice. Jay, let me turn it over to you to begin panel 1. Thank you.
Thanks so much, Alan. And thanks everybody for being here. It's a pleasure to be with you. And I am excited to kick us all off with a fascinating topic. Where can you protest the award of an other transaction authority agreement, or OTA? 2020 gave us major developments in 2 cases, the Spacex case and the MD Helicopters case, and we'll talk about them both in a moment. First, though, let me lay a little groundwork for why jurisdiction over OTA protests is an issue. So on this slide on the far left, you see the statutory definition of OTAs, which for our purposes is important because OTAs are defined by what they are not. They are defined as not being procurement contracts. In the second block, you see the relevant language from the statute that governs GAO's authority to hear protests. And you see that GAO's authority is limited to hearing objections to a solicitation or award of a contract for the procurement of property or services. So GAO's jurisdiction or authority to hear protests is limited to protests of procurement solicitations and contracts. In the third block, you see the Court of Federal Claims jurisdiction. The court has exclusive jurisdiction, and we'll come back to that in a minute, over protests of violation of law in connection with a procurement. And we'll spend some time talking about the meaning of the phrase "in connection with" in this context when we get to the SpaceX case. In the final block on the right, we have the district court. District courts have broad jurisdiction under the Administrative Procedures Act. That jurisdiction used to include the ability to hear protests challenging the award of procurement contracts. That's the old Scanwell case from the DC Circuit. After the Scanwell case, though, Congress took jurisdiction over protests of procurement contracts and put that exclusively in the Court of Federal Claims. But the district courts retained the rest of their existing APA jurisdiction. So with that background, let's move to slide 2. And let's talk a little bit about the SpaceX case. SpaceX involved a 2-phase Air Force acquisition. Phase 1 would result in the award of OTAs for the development of launch vehicles, whereas Phase 2 would result in the award of FAR-based contracts for the provision of launch services. SpaceX did not receive an OTA and protested at the Court of Federal Claims. The court ruled that its jurisdiction is limited to procurement contracts and found that the OTA at issue in that case was not a procurement contract. But that did not end the analysis, because SpaceX alleged that violations that it alleged occurred during Phase 1 were in connection with Phase 2. So how did the court deal with that issue? Let's move to the next slide, please. Well, the court called that issue a close question, and it noted that the Federal Circuit has explained that the phrase "in connection with" is very sweeping in scope. Those were the Federal Circuit's words, very, very sweeping in scope. But the court nonetheless concluded that the alleged errors during Phase 1 were not in connection with Phase 2. The court looked at 4 factors, which you see there on the slide. I'm going to focus on the first of those factors, which seems to be the most important and seems to have driven the assessment of the remaining 3. The court thought it significant that there were 2 separate solicitations. There would be one solicitation for the Phase 1 OTA and a separate solicitation for the Phase 2 FAR-based contract. The court pointed to a line of Court of Federal Claims decisions that stand for the proposition that each solicitation stands on its own, and decisions under one solicitation don't govern decisions under a separate solicitation. And based on that, the court concluded that therefore decisions under the Phase 1 solicitation were not in connection with the Phase 2 solicitation. In addition to the 4 factors that you see there, the court also considered the fact that the competition for the future Phase 2 contract would be full and open. So Spacex would be free to compete under Phase 2 and would be free to bring a protest as appropriate in connection with the award of Phase 2 contracts. Although the court didn't include this in its 4 factors, it seems like a key fact. If the agency had used the award at Phase 1 as a down select to determine who would be eligible to compete for Phase 2, it seems likely that SpaceX would have had a stronger argument that the down select decision in Phase 1 was in connection with the Phase 2 procurement. But those weren't the facts, and based on the facts presented and its analysis, the Court of Federal Claims concluded that it did not have jurisdiction in this case because the OTA was not in connection with the procurement, and it dismissed the protest for that reason. But that's not the end of the story, because the court transferred the case to U.S. District Court for the Central District of California, and we will come back to SpaceX in a few minutes. Next slide, please. That brings us to our second significant case, which is MD Helicopters. And that case involved an Army acquisition for the Future Attack Reconnaissance Aircraft, which is an advanced helicopter. That acquisition was to be in 4 phases. The first 3 would be OTAs for various development stages. And the 4th was to be either a contract or an OTA for follow-on production. In this procurement, MD Helicopters first went to GAO, which dismissed the protest because, as we touched on earlier, GAO does not generally have jurisdiction to hear challenges of the award of an OTA. The one exception to that rule is that GAO will hear challenges to an agency's threshold decision to use an OTA instead of a contract. That's the Oracle case that's in your materials. But this case didn't fall into that limited exception, and so GAO dismissed the protest. For reasons unknown, MD Helicopters then bypassed the Court of Federal Claims and went straight to U.S. District Court in the District of Arizona. It filed there in April of 2019, and the court promptly asked the parties whether it had jurisdiction to hear the case. And the government filed a brief explaining to the court that in the government's view, the court did have jurisdiction. The court explained that the OTA at issue in that case was not a procurement contract, and that it was therefore not subject to the Court of Federal Claims exclusive jurisdiction over protests of procurement contracts, and therefore the court had APA jurisdiction. The court, however, ultimately disagreed. The case proceeded for about 10 months until in January 2020, the court dismissed the protest based on a finding that it lacked jurisdiction. Some commenters at the time concluded that this case stood for the proposition that it cut off any avenue for protesting an OTA. I think it's pretty clear that's not what the case means. So let's talk a little bit more about the court's analysis in the case. Next slide, thank you. There are two parts to the decision. The first part is less important for our purposes, so I'm not going to spend a lot of time on it, but I'll give you the key points so you have the background. In its initial complaint, MD Helicopters, as relief, asked the court to direct the Army to award a contract to it. So it asked for a directed award. The court treated that request as, in effect, a contract claim seeking specific performance rather than as a protest. And the court cited a line of cases for the proposition that the district courts do not have authority to issue injunctive relief in that circumstance. The bottom line for our purposes that this part of the opinion is driven by the relief that MD Helicopters requested. It's driven by the request for a directed award. But MD Helicopters also asked for more typical protest relief. It asked for a ruling that the Army should reopen the evaluation and make a new award decision. And the court therefore separately addressed that aspect of MD Helicopters' claim in the second part of the decision. And in that part of the decision, the court leaned heavily on the Court of Federal Claims decision in Spacex. The court noted that here, unlike in Spacex, one solicitation would govern all four phases of the acquisition. The court also noted that here, unlike in Spacex, each stage would act as a down select for the next stage. And based on those two considerations primarily, the court concluded that the OTA at issue in that case was in connection with a procurement and was therefore in the exclusive jurisdiction of the Court of Federal Claims. Interestingly, the court reached that conclusion even though it recognized, as I mentioned earlier, that the phase 4 part of the acquisition could result in either a contract or an OTA. The court reasoned that because the Army's ultimate goal was the acquisition of advanced helicopters, that the agency's actions, and this is a quote, all took place within the procurement process. So if we had more time, we could certainly have a further discussion about that, but that was the court's conclusion. So the takeaway from this opinion is not that there is no avenue to challenge the award of an OTA. The takeaway is that in the context of this particular acquisition and this particular OTA, the court concluded that jurisdiction rested with the Court of Federal Claims and not in district court. Next slide, please. So where does that leave us? Well, let's jump back to Spacex for a moment. After the Court of Federal Claims transferred that case to district court, it was litigated for over a year until finally in late September of 2020, the court decided the case, and the court decided the case on the merits. It took jurisdiction. So that case stands for the proposition that where the Court of Federal Claims does not have jurisdiction to hear a protest of an OTA, the district court generally will. But the question remains, if you want to protest an OTA, particularly an OTA that is part of a multi-phase acquisition, where do you file? Well, as the analysis in both cases shows, that the answer to that question is highly fact specific. It depends on the particular nature of the OTA and how the OTA relates to the other phases of the acquisition. And on top of that, there is inherent uncertainty at this point because key jurisdictional issues have yet to be answered. And in particular, the Federal Circuit has yet to weigh in on how the phrase "in connection with" should be interpreted in the context of a multi-phase acquisition that includes both OTAs and procurement contracts. Of course, the Spacex case and the MD Helicopters case both address that issue, but neither one of those cases has precedential effect, and they do not bind other cases, other judges or courts. When in doubt, it may make sense to lean towards starting at the Court of Federal Claims, both because the court moves much more quickly, typically than a district court does, and also because the Court of Federal Claims will have more familiarity with the relevant standard in connection with a procurement. We have the good fortune today to have on our panel a couple of folks who have been involved in these cases. Craig Holman, I know you were counsel to Spacex in its OTA case. Do you have any practitioner tips for folks looking at how to sort through this jurisdictional mess?
Sure, Jay, and let me echo the last point on your slide there. I think this is a circumstance that's screaming out for a legislative fix. Getting involved in highly fact-specific jurisdictional fights over where what constructively as a bid protest ought to be heard is in fact contrary to what Congress intended with the ADRA and when it took away the district court jurisdiction all the way back in 2001. We have a forum for these type of matters, and really these, as far as I'm concerned, these type of cases really do belong in the Court of Federal Claims. I think there is a need for a legislative solution here. As a practitioner, I will say when you come across these cases, it's quite, it can be quite stressful at the front end because, you know, the last thing you want as a government contracts litigator, particularly in a matter that requires speed, is jurisdictional uncertainty. And with the Department of Justice on the other side, you know that you're going to get a fight over jurisdiction if there are issues there. And you know, for our case in Spacex, we saw that there were jurisdictional issues. We pled the court's jurisdiction very heavily in our complaint in an effort to try and dissuade the argument. And you know, when the motion to dismiss came, we not only defended obviously very aggressively the motion to dismiss, but we also filed a motion under 28 U.S.C. 1631. I offer that as a tool out there for practitioners. If you look at the Spacex case, what you're going to see at the end of the day, as Jay mentioned, the U.S. Court of Federal Claims transferred the case to the Central District of California at our request. And essentially what 1631 requires you to show is that if the transferring court doesn't have jurisdiction, that the proposed transferee court is one where it could have been brought, and that the interests of justice favor transferring the case. And you know, although that last point may seem broad and daunting, what does that mean, interest of justice? The reality is the case law, particularly out of the federal circuit, is that you've got a viable case that's brought in good faith. So, you know, it's an important thing to remember out there as a tool for practitioners if you are in this circumstance and you want to transition your case, or you want to have the backup of actually transferring your case. That's what we did in SpaceX. Back to you, Jay.
Thanks, Craig. Very helpful tips. So, you know, based on everything that we've just talked about, it seems likely that there will be a period of uncertainty and disruption ahead of us. DoD will continue to award big, important OTAs. And so long as DoD is awarding big, important OTAs for long-term programs, disappointed offerors are going to be motivated to challenge the award of those instruments. As things currently stand, those challenges are likely to take far longer than your typical protest. Of course, a typical protest at the Court of Federal Claims takes about 3 months or so. The MD Helicopters case took about 10 months in contrast before the district court. And the SpaceX case took a total of 16 months, 3 months at the Court of Federal Claims and about 13 months in district court. So there's going to be a fair amount of disruption with respect to that process. And meanwhile, it's likely to take, you know, some time before we get clarity through the court process, just, you know, because of the need these cases for the cases to work their way through the system. So, you know, as Craig mentioned, you know, I have a bullet on the slide here. This does seem like a candidate for a legislative solution where Congress could come in and provide clarity about the you know, the proper jurisdiction for OTAs. So that's all I've got for the moment. And with that, I'll kick it over to Dan and Amy.
Great. This is Amy O'Sullivan. If we could go to the next portion of the materials. I'm going to be sharing my time today with my partner, Dan Foreman, to address a couple of related issues stemming from a very basic concept of who is an offerer and what can be attributed to that offerer, and then the sort of midstream acquisition impacts of changes in control. I'm going to start first on the fundamental issue of offerer identity and what exactly an offerer can rely on for purposes of evaluation from a broader corporate entity. It's actually quite astonishing how often these very basic issues come up. We're going to touch on a couple of cases addressing this, but importantly, it really comes down to, at least from the proposal component of this, of questions of clarity and consistency in addressing the solicitation requirements. So starting generally, the concept of corporate affiliate attribution is actually an area where there's a significant amount of agency discretion. However, it does have to be grounded with support in the proposal itself, which has to include some type of factual basis for how you are going to be wrapping in broader experience, past performance, what have you, from a corporate affiliate, and how they're going to be involved in the actual performance of the contract itself and how resources will be shared. So this attribution issue is not automatic. Now, what complicates this even more is that it actually comes up in a number of different ways, even in connection with a single procurement. And it may actually, over the course of one procurement, be applied in different ways, depending on the very language of the RFP. It can impact experience, past performance. It can go to responsibility determinations. It can go to very specific requirements in a solicitation associated with facility clearances, CMMI, subcontracting plans. So who an offerer is a very fundamental question, but it is one that is very significant because this really sets up the competitiveness of the proposal or even threshold questions of eligibility. Next slide, please. Because so much of this issue really revolves around the solicitation and even a very basic question of whether or not the offer is defined or how evaluation terms are addressed within the RFP, this is an area absolutely where terms must be reviewed carefully. It's an area where I advocate strongly for utilization of Q&As. And again, using it in a way that's advantageous to an offerer's unique circumstances. Utilizing that process as a way to avoid ambiguities, to better position an offerer to compete and rely on the information that it wants to in a particular procurement, and also avoiding then after, once we've set on the terms in the proposal submission phase, ensuring that an offer avoids the dangerous circumstances of inconsistencies in the proposal and also the traps that can arise from situations where you're utilizing generic corporate references. Now, this is where we'll see that a number of these problems have actually arisen in practice. Next slide, please. I'm going to walk through two recent examples in cases where these attribution questions have arisen, both in very different circumstances, but you'll see how these questions arose from the nature of the proposal itself. So in the first case in DynCorp, the issue on attribution arose in the context of subcontracting plan attribution. And the requirements in that specific solicitation refer to submission and evaluation provisions associated with the offerer, again, generic references, but included submission and support for achievement of goals, referring to individual subcontracting reports. Now, the problem arose here because despite references to the general corporate entity, when drilling down to the specifics of the ISRs, the cage codes on those didn't match what was included and identified as the actual offerer's cage code. And that issue was not actually clarified in the proposal itself for purposes of attribution. So ultimately, the protest in that circumstance was denied, and the agency actually was reasonable in its evaluation of the offer as unacceptable. So as you can see, extremely harsh consequences can arise in these particular circumstances because of something that may seem as simplistic as cage code references. Next slide, please. Connected global solutions, it's a different attribution question, not in the subcontracting plan circumstances, but one arises in the context of responsibility determinations. Now, a bit longer history on this particular case, where the responsibility questions actually arose not once, but twice. During the first round of protest litigation, the agency actually took corrective action in response to the protest. Again, to have additional time to consider potential implications of an alleged parent's criminal antitrust violations and how that might impact the offeror's responsibility. Now, importantly, corrective action in that situation was not with the entirety of submission of new proposals, but it did allow, as part of the reevaluation, for communications associated with the responsibility determination. And as part of that, the offeror provided additional information, both clarifying and providing additional very specific statements addressing these questions associated with their corporate affiliates and attribution questions. When the second protest arose, however, the fact that these communications took place ended up creating a separate problem for the awardee and for the agency, in that the attribution questions arose with problems associated with inconsistencies. Those inconsistencies were now between the technical proposal and then those representations associated with reliance on that entity that presented potential responsibility issues. So again, it's sort of a note of caution on very basic questions of a proposal being clear in what resources are going to be relied on for purposes of performance. Next slide, please. I'm going to address a more nuanced aspect of attribution, but it's one that comes about quite frequently because of, very significant reliance, and I believe more so nowadays, on the use of joint ventures. This adds a layer of complexity to the basic question of who's the offeror, because you no longer now, as the offeror, have just one entity, but more than one entity who are in fact in the driver's seat as the prime contractor. Now, companies rely on the JVs for different reasons. Advantages being precisely that you can actually pool the resources of more than one entity into the prime contractor itself, being able to draw on a broader pool of capabilities and being able to address across more than one entity the ability to meet certain requirements in a solicitation. But risks come with that advantage. One of the challenges with the joint venture that goes directly to this attribution question is the fact that it could in fact be evaluated as a new entity. Many of these joint ventures are set up as separate legal entities. So with that comes the risk, for example, of receipt of a neutral past performance, because technically that entity has no performance history. So much like with the broader concept of attribution, reviewing the RFP terms is the key initial step, and utilizing the Q&As oftentimes to address specifically the question of what happens with joint ventures. You say offer broadly, but with a joint venture, are there any unique rules that are going to apply in those circumstances for evaluation? But importantly, in considering joint ventures specifically, this is an area where we have a small business wrinkle. This is where we've seen most of the cases have evolved, as well as regulatory changes that I'll discuss briefly as well, that have arisen for added protections for small businesses in the use of joint ventures. Next slide, please. So first, again, I have two small business cases to focus on that will address some of the regulatory requirements as well as the limitations on those. Starting with Acagra Partners. Now, these are not the only two cases even on small business joint ventures, but bringing you current on sort of what the regulatory state of affairs is. Now that at least makes clear in the context of these mentor-protege joint ventures, consistent with the regulations, that agencies have to consider the experience and past performance of the member companies. But there are, it's not a blanket limitation on agency discretion here. They can still require protege or the small business to submit projects in their own name. Next slide, please. Interestingly, where the problem arose in Acagra Partners was not on that general concept addressed in the regulations, but of a bit of a wrinkle on the oddities of CTAs, which are a bit of a hybrid, almost halfway between a joint venture and a typical prime sub relationship. And in that situation, the agency unfortunately had no explanation for essentially why it was applying a different standard on what information could be considered for CTAs that involved a mentor-protege joint venture and then other CTAs. And because there was no support for that, the agency couldn't actually have that differing treatment. Next slide, please. So more recently in Amaze Technologies, again, tracking some of these regulatory updates, this decision was actually still consistent with the fact that the SBA regulations don't actually mandate a specific weighting or degree of consideration to a mentor versus a protege's experience or past performance. And here the holding in this GAO case was consistent with that. The RFP required submission of certain experience requirements. And importantly, of the 3 references that had been submitted, all were from the mentor of the joint venture. None were from the protege itself. This is actually not uncommon because a lot of reasons why these are used are to enhance the small business capabilities. Only one of those was actually evaluated as relevant. Next slide, please. But here, ultimately, the challenge was not successful because the agency complied with the basic requirement of considering all of the information. Here, it came down to the question of weighting and also the agency's refusal to disregard the fact that the protege, for example, did not have the submission inclusions within the overarching past performance evaluation. So again, there's no requirement with these regulations for the focus to be exclusively on the mentor. Next slide, please. So as I mentioned, with the small businesses, this tracks some unique regulatory requirements. Again, small businesses are more dependent on the use of joint ventures to broaden capabilities, and the regulations have actually been continuing to expand in terms of how an agency is at least required to give consideration to member experience. So whereas before it was limited, for example, the past performance and experience, it's now expanded to include those consideration requirements for capabilities and business systems. Next slide, please. These are effective now, again, with limitations. Essentially, it's now a consideration of this experience, these capabilities in the aggregate. But it does not go so far as to mandate for agencies how that information is supposed to be weighted or the other considerations that they may impose in the small business setting. With that, I'm going to shift to Dan Foreman now. And once we have the basics of identifying the offer to discuss then what happens when things change. Dan?
Thanks, Amy. Appreciate it. Hello, everyone. Now, over the past several years, one unmistakable trend that we've seen in the GovCon market has been a seeming increase in M&A and divestiture activity. And there are a number of possible factors. It could be corporate cash reserves, changes in tax law. But given this level of M&A activity, it's no surprise that we've seen a number of protests that have been raising questions about whether an agency's properly considered the impact of a transaction on a contractor's proposal. We refer to these generally as change in control protests. And with market experts projecting a continued steady stream of transaction activity in 2021, we expect to continue to see these types of protests. And so it's really important, I think, to understand some of the guardrails that GAO has established in terms of how to approach and mitigate risk when you're involved in a transaction. Now, these are highly specific fact-specific cases, GAO reiterates that in nearly every one of these cases. And while there really aren't any bright line rules, there are a couple of key legal principles that are in play. The first really goes to the fact that agencies don't have a general affirmative obligation to go out and search for information about a potential corporate change of an offeror. But GAO has made it clear that an agency is required to consider the impact of a transaction or corporate change when the transaction is, quote, imminent and essentially certain. The second basic principle that's in play in these protests is the notion that an offeror has a duty to submit an accurate proposal, and to the extent that there have been changes or material changes to the proposal or the way the offeror intends to perform, there's a requirement that the offeror update the agency. So those are sort of the basic concepts that are in play. Next slide, please. Turning to the first, which is really the threshold question, when is an agency required to consider the impact of a transaction, and when is an offeror required to disclose a transaction? As noted, there's no affirmative duty for an agency to search for potential transactions, but if they're imminent and essentially certain, they have to be considered, they have to be disclosed. But begs the question, what in the world does imminent and essentially certain mean? GAO did provide some guidance back in 2016 in the Lockheed Martin Integrated Services decision. For those keeping score, it's 2016 CPD paragraph 273. That transaction involved Lockheed's plan to sell its IT and tech services business to Leidos. And in assessing whether that transaction was essentially was imminent and essentially certain, GAO stated that the factors for consideration include, and I'm going to quote, whether the timing and manner of the spinoff contemplated were within the control of the offeror, and whether the offeror had disclosed detailed plans to the SEC, including an anticipated time frame for closing the transaction. It's sort of helpful, but far from definitive. So as we continue to search for what this phrase imminent and essentially certain means, another place to look is the SBA setting. And in the context of affiliation determinations, the SBA has held that a non-binding letter of intent doesn't trigger affiliation, but a binding letter of intent does. So I like to sort of think about the general rule of thumb here is that a deal is going to be considered certain at close, and it's going to be likely and imminent at signing. Not a perfect science, but a general rule that I think is good to follow. Next slide, please. So turning to some of the more recent cases on the change in control subject, I'd like to start with VSE Corp, and that's 2019 CPD 413. And I think GAO's decision in this case provides a helpful framework for how to approach change in control issues. And the slides have a timeline of the key events. They are somewhat convoluted, so I want to just, in a nutshell, give you a summary. It was an Army procurement task order RFQ. And AECOM, which was one of the parties involved, it announced that it was spinning off AECOM Management Services, which is the actual bidder, into a new public company. And that announcement was made after the agency issued the task order solicitation. Unaware of the announced transaction, the Army went ahead and awarded to AECOM. And during its post-award debriefing, VSE, which was a disappointed offeror, it raised the AECOM transaction and asked whether the agency had considered the potential impact during the evaluation. And according to the agency, this was the first it had heard of the planned spinoff, even though the record showed that there were public statements about the transaction. Nonetheless, the Army went back and completed a second responsibility determination, and again reached the same conclusion and awarded to AECOM. VSE protested that decision, and the day before comments were due, AECOM announced that AECOM Management Services would not be spun off as a public company, but instead that AECOM was selling its equity interest in that entity to two private equity firms. In terms of the GAO decision, the GAO was easily sort of to quickly dispatch of the VSE protest because the challenge to the spinoff plan that no longer was going forward had been rendered moot, and any challenge to the decision to sell to the PE firms was post-award and therefore not something that the agency could have considered. But nonetheless, GAO went ahead and it still sort of walked through the analysis as to VSE's arguments about the potential impact of the AECOM transactions, and in doing so, provide some helpful guidance. And GAO started, I think, at the right place, which is answering the question of whether the agency was aware of the transaction as well as its imminence and certainty. And again, GAO concluded that the initial plan to spin off a new public company was not imminent because AECOM canceled the plan, and that the plan to sell to the PE firms was announced after award, so it couldn't have been known. Now, GAO also went forward, though, and could have stopped there, but it continued, went forward and examined whether the divestiture would have meaningfully impacted AECOM's performance on the task order. And GAO found it significant that the transaction was a stock deal and not an asset sale, and ultimately concluded that the bidder would also be the same entity that performs. GAO also found out noteworthy that it was a fixed price procurement. And so to the extent that there were going to be changes to cost reimbursable rates from the transaction, it wasn't going to impact the fixed rate proposal. Next slide, please. Actually, if you can go one further, these are just additional facts from the case. So the next decision I'd like to talk about is the Weil Labs 2019 CPD 19 decision. This isn't to be confused with the 2014 Weil Labs matter. And in that earlier decision, as everyone recalls, one of the seminal cases in this area, GAO sustained Weil's challenge to NASA's failure to evaluate the impact of the planned split of SAIC into two independent publicly traded companies. And as everyone likely remembers, that is the transaction that led to the creation of Leidos. Now, GAO ultimately found in the earlier case that the award was based on the proposal submitted by the old SAIC, but the contract was going to be performed by the new SAIC, which is going to be a smaller company, and that the failure to consider that rendered the evaluation unreasonable. So now let's fast forward to the 2019 Weil decision. And this time Weil find itself sort of on the other side of the changing control issue. And again, the key slides, the key facts are on the slides, but I just want to run through because they are, again, a little bit confusing. In this instance, CBP issued an RFQ in June 4th, 2018, and it was a competition limited to GSA OASIS contract holders. The day after the RFP came out, Weil, which was an OASIS holder, entered into an asset purchase agreement with Grant Thornton, which did not hold an OASIS contract. And about 9 or 10 days later, Weil and Grant Thornton submitted an ovation package to GSA. And Weil also submitted to CBP its proposal in response to the RFQ. And that proposal made clear that Grant Thornton was actually going to be the party performing the work, and that Weil was simply serving as the prime, basically for administrative purposes, until GSA approved the novation. Now, other than submitting the proposal on Weil letterhead, the proposal was all about Grant Thornton's performance. Next slide, please. CBP initially evaluated the Weil proposal and actually assigned it outstanding ratings under both technical and management approach factors, but then went on to find that Weil was unawardable because CBP wouldn't be in privity of contract with the entity that was actually performing, which was Grant Thornton. So CBP went forward, awarded it to Deloitte. Weil protested. And in its protest, Weil really focused on the fact that it had received outstanding ratings. And it argued that those ratings showed that the agency believed that Weil was still capable of performing. GAO roundly rejected that argument, finding that the preliminary ratings were really inconsequential because they focused on the capability of Grant Thornton to perform, not Weil. And GAO found it completely reasonable, the agency's concern about not being in privity with the party who would be performing, and noted that it was entirely possible that the novation package wouldn't be approved, thereby creating risk for the agency. Next slide, please. The next decision I'd like to just touch on is Nightpoint, which is a 2020 case. It involves another variant of the change in control cases. The ones we've really been talking about are questions of whether a party has divested itself of assets and whether it impacts a proposal. 9-point involves a different situation. And in full disclosure, I was part of the Kroll team that represented 9-point in this matter. And it involved a Coast Guard procurement under 8.4. It was limited to Schedule 70 holders. 9-point, which does hold the Schedule 70 contract, was actually eliminated from an early phase of the competition on the basis that the Coast Guard was confused about the identity of the actual offeror. The Coast Guard asserted that the offeror appeared to actually be 9-point's new parent, Prospecta, and not 9-point. And just 9-point had just recently been acquired by Prospecta shortly before this procurement. The Coast Guard actually, before disqualifying 9-point, asked 9-point to clarify who the actual offeror was in the relationship between 9-point and Prospecta. And 9-point explained very clearly that it was the offeror and that it would be the prime for performance, but that it had its parents' backing for support and resources, which is a quite common situation. Now, notwithstanding the clarification, the agency still disqualified 9-point, and it did so in part because the proposal was submitted on the parent's letterhead and it used the parent's name throughout their proposal. But in its protests, 9-point was able to show that the proposal cover letter identified 9-point as the offeror, and importantly, the proposal identified a single DUNS number and a single cage code which both belong to 9-point. And those facts were ultimately critical to GAO, which went on to sustain the protest. And in doing so, GAO acknowledged that while uncertainty as to the identity of a bidding entity renders a quote unawardable, there was no such concern where it's clear from the quotation which entity would be bound to perform. And in this instance, GAO found, in particular, relying on the cage code, that there was no dispute or no uncertainty. And even if there was, that it was completely cleared up. It was cleared up during the clarification process. So let's just sort of next slide, please. Just to take a step back and sort of return to where we began, assessing the impact of a change in control. It's highly fact specific. The cases do give us good insights into the types of questions that practitioners should be asking when having to analyze these types of matters. The first and foremost is the transaction imminent and likely certain? If it's not, then there's nothing for the offeror to disclose, and there's nothing that the agency is required to consider about the potential transaction. But if a corporate change is imminent and likely certain, the offeror must disclose, and the government must consider what impact the transaction will have on performance. And that assessment is going to turn on things like whether the offeror is selling resources and personnel that were fundamental to its proposal. Will the government still be in privity with the offeror, or does the transaction mean that a different entity will perform? Is it a stock transaction, or is it an acquisition of assets and merger into a new company? Is it a cost contract? And if so, will there be a change to the rates? And so these are the types of questions that you should ask when you're going through and trying to analyze a change in control fact pattern. And of course, just a next slide, please. Of course, as practitioners, we want to figure out how we mitigate the risks, and there are several practical considerations. I mean, in a perfect world, you can time your transactions so that they don't interfere or overlap at all with important procurements. We all understand the reality of the M&A market, and that luxury is not often afforded. But there's still things that you can do. When you're engaged in a potential acquisition, it's important to, during the diligence process, to look for pending proposals from the target or your potential tie-up partner. See if those proposals could be impacted, because that could impact your valuation. It's also really important, at a minimum, sort of under the do no harm principle, that you avoid the risk of a material misrepresentation. So if you're involved in a transaction that's imminent and likely certain, it is critical that you disclose, because not only does not disclosing create protest risk, it could create a T for D on the grounds that the proposal was inaccurate, and that could lead to reprocurement costs. So there's a lot of reasons to make sure that your proposal is accurate. Now, second, if you're in a position where you have to provide the notice, and importantly, where it's accurate for you to say so, it's important to assure the agency in your notification that the entity that submitted the bid is going to be the same entity that's performing. It's got the same resources. It's not going to impact costs. It's not going to impact financial wherewithal. And when you make those communications, it's critical that you do so under the guise of a responsibility determination communication, because that is outside the scope of discussions and it is another way to help mitigate risk. And finally, we've been really talking about the defense here, but there's also some offense involved. So as you're thinking about potential protest issues, it's important to monitor your competitors for changes as they could give rise to potential protests should you not prevail in a competition. And with that, I'm going to turn it over to our next presenter, Craig Holman from Arnold & Porter.
Thanks, Amy and Dan. It was very insightful. Next slide, please. I'm going to take a few minutes today to talk with you all about corrective action at GAO. And I want to start by saying in the midst of all these important topics, why is this one something practitioners should care about? And I submit that this point is clear immediately once you look at GAO's annual report to Congress, provided each year by GAO, the latest report issued just in December of 2020. One of the last statements in GAO's cover letter to Congress notes that a significant number of protests filed with GAO do not reach a decision on the merits because agencies voluntarily take corrective action in response to the protest rather than defend the protest on the merits. Now, all of us as practitioners see this and we understand this. And so it's important for us to get a sense from these numbers of exactly how often this is happening. And then we can talk in a little more detail about why it's so important and why it's happening. First, as my second bullet point says here, GAO's numbers, and we'll drill down on this in a second, suggests that more protests may end by corrective action than by GAO merit decision. And second, if you looked at the FY 2020 GAO report, you notice that there's a 51% effectiveness rate for the protester. Again, if we drill down on the numbers, what we're going to see is that effectiveness rate is actually largely driven by corrective action, not by GAO decisions. Next slide, please. So here are the numbers from December 23rd, 2020, filed with Congress by GAO. I'm going to just focus on the fiscal year 2020 line, but these are in your materials if you want to look back, and certainly GAO has accessible back many, many years on these statistics if you want to see what's happening at GAO. The first important thing I want to say about these numbers as we look at them, just to make sure we level set for everybody here, is that the numbers are done by unique B number. So if you have a 0.2, a 0.3, a 0.4 protest, they're all counted as separate cases. But let's see how these numbers look. In fiscal year 2020, GAO had 2,137 cases closed. If you look at the cover letter, you're going to see about 100 of those are cost claims and requests for consideration. Let's take those and let's put those to the side. Of those, 545 end up in some sort of merit or sustain decision. So you get a substantive GAO decision at the end of the case, roughly 545 times. So now we're looking at about 1,500 cases that are still hanging out there. And of course, I'm sure a number of cases are dismissed because protesters don't properly plead them. But the reality of the matter is based on these numbers, it seems all but certain that GAO has more cases ending by corrective action than by decision. So understanding what's happening and how to protect your rights as a protester, or how to properly effect corrective action as an agency practitioner, is really critical to practice before GAO. And I will note in this regard that there are GAO's rules on lots of things, but on corrective action, it doesn't have much by way of rules. It does have rules on how to request reimbursement, for instance, if you're seeking corrective action. But what is proper corrective action? What do you do as a protester if corrective action occurs is really a product of GAO's decisions. And 2020 in that regard was a big year. Let's take and look at the next slide and talk a little bit about what happened in 2020. First of all, I think largely as a product of the fact that there is uncertainty out there in the practitioner bar regarding corrective action, and some lack of clarity as to what is adequate corrective action and how do you have to challenge corrective action. We see a lot of protests in this area. And I think very fortunately in 2020, GAO has begun issuing more detailed decisions on corrective action. And first and foremost, it started to tell us what GAO believes moots a protest. And there are decisions going back years, so I don't mean to suggest that GAO hasn't been doing this. But certainly in 2020, we had a number of decisions that tell us in greater detail what moots a protest. So let me start on the pre-award side with the Mythics and Oracle case. That's that 2020 CPD 295. This is a Library of Congress procurement. And actually, this case caused a lot of interest in the procurement community for a number of reasons. But one reason was whether GAO was sending a message about how to moot a protest by corrective action. And significantly, when you drill down and look at the Library of Congress decision, what you see is that it was a pre-award protest. There were a number of significant issues where allegations were made with respect to how the solicitation was structured were lawful. And GAO, despite that the agency on a number of occasions came in and said they were going to take corrective action, didn't believe that the agency had adequately explained how it was going to take the corrective action. And indeed, this is chronicled in the decision. In some instances, the agency expressly said it was not going to change how it was acting. And basically what GAO said it took the decision to the merits, and ultimately when it wrote its decision, it said vague, ambiguous, or partial or inadequate statements on the part of the agency to take corrective action at an indefinite point in the future do not moot a protest. And this is particularly significant in the pre-award context we'll see in a second. But this language actually from GAO's decision on the screen ended up getting cited in some other corrective action scope challenges in 2020. So we're going to get a chance to see how GAO talked about the Mythics and Oracle decision from the fall of 2020 and some of its late 2020 decisions. Next slide, please. The next case I was going to mention is the Raytheon Company case issued on December 22nd, 2020 CPD. We don't have the paragraph number yet. This case is important because it deals with post-award protest and corrective action. And indeed, in this particular case, there was quite a bit of argument about what was the meaning of the Mythics and Oracle decision that we just talked about. And one of the things that was going on in the Raytheon case, and I'm going to come back to, and we're going to see as a theme through some of these cases, is there was a lot of confusion between the agency and the protesters' council about what the agency was intending to do and not to do during the corrective action process. And effectively, because of that confusion, imagine that the protesters' council felt like they had to file essentially a protective corrective action scope protest to protect Raytheon's rights. And they did that. GAO ultimately decided that the protest was ripe to be dismissed as premature because the agency had not yet reached a conclusion on whether to engage in discussions, whether to amend its proposal, whether to take new proposals. And essentially because of that, GAO found the protest premature. Let's go to the next slide. In a similar decision in late 2020, GAO also dismissed an Odyssey Systems corrective action scope challenge brought by the protester. Again, so protester files protester gets corrective action. Protester then comes in and says the scope of the corrective action is not broad enough. GAO again in Odyssey Systems dismissed the challenge as premature. What was significant really about Odyssey Systems, and perhaps different from the Raytheon case, is that in Odyssey Systems, the Protesters Council was arguing that the reevaluation could only come out one way, and therefore GAO ought to take up the protest at that time. And essentially, GAO again said they're not going to be in the business of guessing how procurements are going to come out when an agency takes corrective action. And so they dismissed the protest as premature. As they said, they declined to rule on a protest challenging the agency's prior actions because they're rendered academic. The agency had taken the protest back. Let's go to the next slide, please. So we see right now that there's a lot of tension, and we're seeing a lot of protests like Odyssey and Raytheon. Leidos is another one here, where experienced protester counsel are filing scope corrective action protests. And it's important for the system and the process, I think, to take a step back and ask why. Why are experienced protesters counsel doing this, and how can this perhaps better be addressed for the system? And the answer is indeed, I believe, in the lack of clarity that many on the protester side feel with respect to these protests. And you can see that in the Leidos decision. The Leidos decision, I'm going to talk about this. What is the timing of corrective action scope protests? Well, what we know from all the way back in 2008 with a domain name decision is that, look, if in a post-award context, if you're the protester and there is corrective action taken and it specifically rules out a specific type of relief, in that case, domain name involved a circumstance where the agency had effectively ruled out discussions, GAO has treated that as a ground rules challenge, putting you on the clock. So what happens with these timing of, you get these corrective action cases that we've seen, Raytheon, Leidos, you look at these cases, what you see is that the agency is saying things in each of these cases that's causing the protesters council to be uncertain about whether they're changing the ground rules, whether they're restricting the ability, or whether they're saying they won't take a certain type of relief. And in Leidos, what we saw, the Leidos case that's in the materials that you have, is that the agency actually affirmatively said that they weren't going to do discussions. And then they affirmatively said they were going to do discussions. So Leidos counsel, realizing that domain name presumably was out there, filed the protest. Ultimately, GAO dismissed the protest as premature, essentially saying the two conflicting statements neutralized each other. But it's important to realize that domain name is hanging out there as a protesters council, in that where there are suggestions that an agency is not going to amend a solicitation, an agency is not going to conduct discussions, you are potentially on the clock as a protester. And sensibly, as Leidos counsel did in that case, you file a protest to make sure your client's rights aren't harmed. And in that particular case, GAO dismisses the protest as premature, and Leidos can come back later. Now, how does the timing change if you are the awardee? Well, if you're the awardee, the timing changes if you get corrective action because you're immediately on the clock. You're on at GAO, a 10-day clock. And Unisant, which came out in January of 2020, made clear of that point. Unisant actually timely challenged the corrective action, but it didn't raise a number of its arguments. So footnote 4 of Unisant makes clear that as the awardee, if you want to protest corrective action at GAO, you need to do it within 10 days. And footnote 4 is a good lesson in that regard from Unisant. But as a practitioner, there are a number of issues to me that you can take away from this. First of all, I'm going to presume, let me start different scenarios and tell you how I take these cases to impact the procurement system, and how we as practitioners can all perhaps do better to avoid the need for protective protests and dismissals. First of all, I'm going to presume that most of the time agencies are taking corrective action. they don't want an immediate corrective action scope protest brought against them. That's not how they want to use their time, and it's not how they want to use their resources. But agency counsel have to understand, if they say things like, we're not going to conduct discussions, we're not going to address this particular argument, that's the inevitable result, because counsel on the practitioner side, faced with decisions like domain name, have to protect their clients' rights. So, for the agency counsel out there, if you're not looking for a scope protest, I mean, you can always put in your corrective action notices that the agency is going to consider all of the arguments. Agency reserves the right to take relief on all of the issues. Those type of statements will effectively cut off the need for a corrective action scope protest under GAO case law. As practitioners counsel, we need to understand when we get these corrective action notices in, that one of the best things we can do is try and communicate with agency counsel. And if we are concerned that our clients' rights are going to be cut off, make that clear to agency counsel, do it quickly, so perhaps you can get some clarity on the agency's position before the corrective action is dismissal occurs at GAO, or if not, immediately thereafter. And of course, as a practitioner's counsel, you also have to assess your rights, your client's rights, and be aware that cases like domain name are out there, and that if you can't get that type of clarity, you may need to bring an action. And if you need to bring an action, a protective action, and the worst thing that happens to you is a corrective action dismissal, I think that's probably better than losing your client's rights. So, Rich, did you have any thoughts you want to kick in on this?
I think you nailed it. When you get a corrective action notice, it's important to look at what the agency has said it will do, what the agency says it will not do. If it has shut down a particular remedy that has been requested, or it has said it will take a certain action that would shut down that particular remedy, I think based on the existing case law, you have to think hard about objecting to that, or protesting, or reserving your rights to protest in the future. I agree with you that it's important to talk with agency counsel in that situation and try to reach some kind of resolution. And if necessary, if you're at the GAO, to see if the GAO attorney can help reach that resolution. In my experience, the GAO doesn't want a corrective action protest right after corrective action is taken either. And so it really benefits all the parties if you can work together and identify what exactly is going to happen in the corrective action, and what rights will the protester have when the new award decision or next step in the process is taken.
Thanks, Rich.
We'll
go ahead.
This is Kevin Mullen.
Yes, Kevin.
I have an observation. On slide 32, when you showed the GAO statistics and the jump in the effectiveness rate to 51%, I also noticed a jump in the use of ADR, and I think they're connected. I think that the logic of causation goes from an increased use of ADR and then an increased prevalence of corrective action, and that increases your effectiveness rate. So I think there is a connection there. The other thing I would observe is that 51% effectiveness rate. When your clients hear about that, they get real excited. But that number, in my view, is misleading, because it includes every B number, 0.1, 0.2, 0.3. We know with supplemental protests, you can get a bunch of 0.1s through whatever. And if that protest results in corrective action or some other remedy that fits within the effectiveness rate, it drives it way up. So I think we all know as practitioners, and the agency counsel know as well, that really the number as a practical matter for judging whether you should file a protest and what your statistical chances are nowhere near 50%. Just an observation.
And Kevin, I agree with that. I think those are good points. And just your point about the B number, a few years ago, I think it was in FY26, there was one, what we would refer to as one protest that was sustained. I think the B numbers went up to dot in the high 30s, .37. And as a result, the number of sustains went up by 37, and the sustain rate in that year was higher than it has been in other years. So you're exactly right to highlight that point about the B numbers.
Thank you all. Those are great thoughts.
Well, Kevin,
Yep.
I'll add one other thing, and Craig, to yours as well. Many of their clients believe that the effective rate equals I'm getting a contract. And that too is a misnomer in this business. So you got to be very clear in your counseling the clients that just because there's a 51% effective rate or an 82% effective rate on the ADR, that doesn't mean you'll get a directed award.
Right, that's called the lottery rate or the unicorn rate, Alan.
Right.
Thank you, Alan. Good points. Kevin, I think we're over to you.
All right. Well, this afternoon, next slide, please. I'm going to talk about what I consider to be the offeror's dilemma, the problem presented by unavailable key personnel. It's also the agency's dilemma, in my view. So we know the circumstance. You have an RFP in the services area. It includes an express requirement to identify certain key personnel. Many times they ask for a resume as well. And during that limbo period between the submission of your proposal with your key personnel identified and the contract award, one of your key personnel becomes unavailable. That's the problem we're talking about. Now, under the current case law, the offeror has an affirmative duty in that circumstance, if they have actual knowledge of the unavailability of even one key personnel, to advise the agency of that. And in that instance, when the agency hears about it, they only have two options, and two options only. Option one, they can open discussions with all the offerors in the competitive range. This will allow the offeror with the unavailable key personnel to remedy that problem. And option two, the only other option, is to declare that offeror with the unavailable key personnel ineligible for award. So there's our problem. And that rule, driven by the policy that if an offeror determines its proposal no longer represents how it would perform, and therefore an evaluation of the proposal would be unreasonable, that policy drives the duty of the offeror to advise the agency and puts the agency in that box of only two options. It disrupts a lot of procurements at the 11th hour through the protest process. Next slide, please. Now, this rule is particularly unforgiving. It applies in most every instance when the offeror has actual knowledge of the unavailability of even one key personnel. And it applies even if the offeror is not at fault, did nothing wrong. It wasn't foreseeable that this key personnel was going to become unavailable after the submission of its proposal before award, but it doesn't matter. The rule is near ironclad. In the Chenega Healthcare Services case that's on slide 39, this unforgiving nature of the rule became very clear. In that case, Chenega was the incumbent contractor, was competing for the next version of that contract, the recompete. And in the RFP, there was only one key personnel, the general manager, they called it. And Chenega, while performing its incumbent contract, after submitting its proposal for the recompete, learned that its incumbent general manager, who was also the same gentleman proposed as the general manager key personnel for the recompete, that individual became unavailable for medical reasons, not foreseen, nobody's fault. So consistent with the requirements of the incumbent contract, Chenega advised the contracting officer, our current GM is no longer available. We have a substitute GM with credentials that more than satisfy the incumbent contract. The contracting officer said, that's great. we approved the substitution. But by the way, Chinega, what's the story with your GM on your proposal for the recompete? It's the same guy. So he's not available, is he? The answer from Chinega was, well, that's right. But what's the problem, agency? You've just approved our substitute for the GM under the incumbent contract. We would propose the same person. Shouldn't be any problem for the agency, correct? Wrong. The agency was held firm by the rule with regard to unavailable key personnel. The agency only had one of two options. Either open discussions, allow Chinega to fix a problem, allow other offerors in the competitive range to address any other issues in their proposals, or number two, and it's the only other option, declare Chinega ineligible for contract award. Well, in this instance, the agency unfortunately chose door number two. Chinega was out, and its protest to GAO was unsuccessful. Now, that shows you how difficult this rule is. One key personnel approved substitute under the incumbent contract, and still no tolerance for the unavailability of that key personnel in the proposal. So, to make matters even worse, we have other recent case law in the MC Dean case that makes it clear that not just physical unavailability will trigger the unforgiving rule, but also if the person, the key personnel, is not available by virtue of the fact that he or she can no longer perform the contract requirements. In this instance, MC Dean protested under your typical scenario, right? The protester scours the internet, LinkedIn, all day, looking at LinkedIn and talking amongst themselves after award. Who at the awardee do we think is among the key personnel, and where are they now? And are they still available? And that kind of diligence, they can develop a position that's worthy of a protest that could survive a motion to dismiss. And that's what happened here. So MC Dean challenges the availability of key personnel. It turns out that the record supports that. And in particular, there's a person proposed as key personnel by the awardee who has had his security clearance declined. And as a result of that, because the RFP required that clearance, he could no longer perform as a key personnel. So in that instance, the protest was successful and the awardee was out of luck. So it shows you it's a tough rule, not only from a physical perspective, but from a practical perspective. Next slide, please. Now, luckily, the rule has a limit, and that rule is it's only triggered if the offeror in question, the awardee in question, under a protest example, has actual knowledge of the unavailability of the key personnel. Constructive knowledge, should have known, that's not going to trigger the rule, luckily. So you have to have actual knowledge. So a good example of that is the recent case in NCI Information Systems at GAO. In that case, the situation that developed was with a twist. Craig, from your perspective, it was during corrective action, so I know you're going to find this exciting. So what happened was typical unavailable key personnel situation. Protester files a protest, but in this case, the first time around, it's traditional grounds. We disagree with the evaluation on the technical side, on the cost side. We disagree with the best value determination. GAO looks at it, does an ADR outcome prediction, agrees with the protester, tells the parties, and especially the agency, the likelihood here is that we're going to sustain the protest. The agency hears that, goes back and does a reevaluation, but lo and behold, awards once again to the original awardee. Well, NCI protests again, but this time after corrective action, NCI protests raising very much the same traditional grounds, but throws in there the unavailable key personnel, right? They went on the internet, they went on LinkedIn, they found someone who is no longer available because they see that he moved to a different part of the country and they think they have the silver bullet. And in their second protest after corrective action, they include that. And as it turns out, this case put a line in the sand on actual knowledge only to trigger the rule. And that is because the CEO of the awardee submitted a sworn declaration that the company was not aware that this key personnel became unavailable during corrective action. And it was quite credible because not only was it sworn, but it explained that this person was actually working for another company. Never took back his commitment letter to work for the company in the event of award, never advised them of it. In fact, they heard about it for the first time during the protest. GAO said this is a case where the unavailability of key personnel rule is not triggered. Now, next slide, please. You can go to the next one after that even. What's interesting is GAO did not get to what I think is an interesting question. After the initial award, should the unavailability of key personnel rule even apply? Because there was an initial award, usually that cuts it off in terms of the timeline. There's no longer a need to address unavailable key personnel. In a protest regime, that's a problem of contract administration. That was not addressed here in the NCI case. Next slide, please. So here we are. Here's our problem. You've got procurements that take longer than anyone would like. You have the use of key personnel as a material term in the RFP. And you have these problems that come up with people moving away, making decisions about their life and their career, and they create the unavailability of key personnel, and they put the offeror in an untenable position, and they put the agency in an untenable position. So what is an offeror to do? Well, there's only a few things that can be done. One is get letters of commitment and impress upon your key personnel just how important it is to remain available until contract award. The other thing is, and it's a perverse result, I think, is that the offeror goes into a dark period, so to speak. Once they submit their proposal, they don't want to hear it. They don't want to ask about the availability of key personnel. Now, that might be something that's doable if, like NCI case, the key personnel are with another company, out of sight, out of mind. You don't know everything they're doing every day. But if they're your employees, that's much more difficult. All right, what's an agency to do? I think that's even tougher. The agency has to make a deliberate determination when developing their RFP. How important are key personnel? Make deliberate determinations about how many key personnel should you have for the RFP. Because the more you have, the greater chance that you're going to trigger the unavailability rule. And I think ultimately, after making those determinations, if an agency is really concerned about it, let's say there's a lot of key personnel that they have in the RFP, perhaps a staggered approach to proposal evaluation would come into play. You do a full-up evaluation, you have a tentative award decision, you then reach out to offerors to confirm the continued availability of all their key personnel. Any that are no longer available, they provide a substitute with a resume, and in days, you reevaluate, adjust your evaluation and your award decision if necessary, and you make an award determination. You can pretty much eliminate the possibility of a key personnel problem coming up. That's all I've come up with, though. And I'm wondering, Alan, from your interaction with industry, whether you've heard about this problem and maybe any other solutions.
Well, Kevin, I didn't realize I was going to be a panel member here, but happy to try to address it. this is very common, as you said, particularly in the services world. Another's we're trying to address this in multiple ways. One other way to get at it in the pre-award area, in the solicitation, is to take that key personnel clause and the right of substitution and put it in the solicitation. If the agency opens that window, then you avoid the die by death, either by hanging or shooting, the choice the agency has to make. Because it's awful hard to, particularly when it's outside the control of the offeror, as you said. What's in the interest of the agency will vary greatly by cases, and that provides no predictability or consistency for offerors. So an additional solution, you've got many of them already in place, good suggestions. I'd add, try during the solicitation phase to recommend to agencies, and we had been pushing this for some time, my prior position, to get them to allow for a substitution should it be outside the offeror's control, such as the medical issue, unfortunate death or something like that. So another way of getting at it. Thank you.
Evan, this is Dan. Another thing that we sometimes advise our clients, we've seen situations where an RFP or an RFQ may only require 3 key personnel positions, and the client wants to demonstrate how sophisticated their team is, and then they sort of voluntarily add 5 or 6 additional key personnel positions. And so that's something that I would advise clients to avoid. Limit the number of key personnel identified as key personnel to the minimum requirements of the RFP or RFQ. Don't classify people as key personnel, because it just increases the chances that you'll have a problem. And I think another point that is particularly troubling is there's 2 cases. They're a bit more obscure, but there's a T3I case, and then there's the Patricio Enterprise GAO decision, and both of them are sustains where the personnel actually weren't identified as key but weren't available, and the cases turn on the fact that the proposal relied heavily on those individuals, as did the evaluation. So it sort of tracks more to the material misrep. They were agency relied on the representation even though they weren't key. But I think this problem at the moment arguably goes even beyond key personnel, and in certain circumstances can get you into trouble with ordinary personnel if you play them up in your proposal and the agency relies on that in the evaluation, they turn out not to be available.
Kevin, and I would just add to Alan's point, what can agencies do? We've seen at least one solicitation where I think an agency tried to do something along the lines of what Alan is suggesting, where the agency said, look, you have to propose key personnel, but when we evaluate those key personnel, what is important to us is not the individual, but the qualifications that you are proposing. And we're here to tell you that if you lose that key personnel, we're going to require you to provide somebody with similar or better qualifications. But in terms of our analysis, our evaluation of materiality, it's going to be the qualifications you're proposing to bind yourself to, not the individual. So we've seen something like that in a solicitation. I haven't seen that, personally at least, I haven't seen that kind of provision go before GAO yet. But that seems like a potentially creative solution here.
Very good. Well, with that, I'm going to promote myself to moderator, Alan, and pass it along to Rich Rector.
Thanks, Kevin. I've got a number of cases here on timeliness, and in the interest of timeliness, I'm going to focus on the first 2. I think we have enough time to cover the first 2, being Inserso and Harmonia Holdings Group. And those are 2 cases, one from the Court of Appeals for the Federal Circuit, one from the Court of Federal Claims, that both address the pre-award standard for a timeliness of a protest at the court. The first case, Inserso, is a case that I represented the protester on at both the Court of Federal Claims and the Federal Circuit. And in that case, the Federal Circuit held that Inserso's protest was barred under the so-called waiver rule that was created in 2007 in the case of Blue and Gold Fleet v. United States. So as background, the Blue and Gold waiver rule holds that if a party has the opportunity to object to the terms of a government solicitation containing a patent error, and it fails to do that prior to the close of the bidding process, then it waives its right to protest that later at the court. So that rule's been around for a long time. Doesn't surprise any of the panelists here. It's very similar, if not substantively similar, to the GAO's rule that's built into the GAO's regulations on pre-award protests. So why is inserso meaningful? Why is it noteworthy? I think there's two reasons. First, the Federal Circuit arguably expanded the blue and gold waiver rule for the first time beyond a patent error in the terms of a solicitation to include a patent error in the ground rules of a procurement. There's room for debate on that issue, but we'll talk about that a little bit more. The second thing is that there was a very strong dissent in the case. There was a majority opinion, two of the judges on the panel, there was a dissent. Judge Reyna was the dissenting opinion, and he wrote a very strong dissent in which he found that the Federal Circuit had expanded the blue and gold waiver rule, but he also found that the viability of the blue and gold waiver rule going forward was in question. And he cited to a case from the Supreme Court in 2017 to question whether the viability of blue and gold would continue. So both of those important points come out of the dissent, essentially. But we'll talk a little bit about those and where they are. Now, a few quick facts on the background of the procurement that are important to understand. Critically, this was a two-track procurement. So this was a procurement where there was a full and open suite of competition and a small business suite. And small businesses could team with large businesses, but they could only win one award, either in the small business suite or in the large business or the full and open suite. The solicitation anticipated 20 awards, so it's a multiple award IDIQ. It's the Encore 3 contract. Originally, and this is important to the decision, originally, when the solicitation is issued, the two tracks are kind of lockstep. The process for each of the two tracks is the same, the schedule is the same, the anticipated award date for the full and open competition is the same as the anticipated award date for the small business competition. But about a year into the procurement, they diverge, and the full and open competition is awarded first. In fact, 7 months in advance of the small business suite. And so that divergence of the two tracks of the procurement creates the issue in this case, because after award of the contracts in the full and open suite and the debriefings are held, there were 4 opportunities on the small business side to amend your proposal. So there's multiple opportunities on the small business side for offers to revise their pricing after the full and open awards have been announced. The issue is that the RFP requirements, the solicitation requirements in terms of pricing were almost identical. So you had the same statement of work, you had the same labor categories, you had the same estimated quantities. The pricing was really virtually identical, at least the structure of the pricing was identical on both procurements. So the agency awards on the large, I keep saying the large, the full and open side, and it provides debriefings to those offerors. And in those debriefings, it provides the total evaluated price for each of the 20 offerors in the full and open competition. And it also provides excerpts from the offerors' cost and price evaluation reports that explain how the agency did the cost and price realism analyses that were conducted in the procurement. So on the full and open side, there's a disclosure of pricing, what are the winning prices, and there is a disclosure of what are the important levers within the procurement that the government focused on in terms of pricing and realistic pricing. So my client, Inserso, gets their debriefing in the small business procurement 7 months later, after the full and open awards have been made. And my client learns that it was 23rd in line for award. It was the 23rd lowest price. And this was an LPTA procurement. So it was the lowest 20 offerers received an award, and my client was 23rd. But it was only 0.2% off. So a razor thin price procurement. And the client also learns at that point that who the other 20 successful small business offerers are. And it's clear that there are a number of joint ventures between small business awardees and large businesses. And my client does some internet research and says, oh, wait, looks like there's 4 or 5 or 6 small business JV awardees and that have a member of that joint venture that also competed on the full and open side. And so by competing on the full and open side, those companies got sensitive pricing information about the procurement. They got a target range of prices from the full and open competition. And because they also were competing as part of a JV on the small business side, they received, their partners received an unfair competitive advantage. That's the argument that Inserso brought in its protest. So we filed initially at the GAO. Another offer filed at the Court of Federal Claims on a different ground. So GAO dismissed, and our protests ended up at the Court of Federal Claims. Now, the court issued a decision in which it agreed, the Court of Federal Claims agreed in concept that both an organizational conflict of interest and unequal treatment of offerors could occur in a situation similar to what we alleged, which was this 2-track procurement. But the Court of Federal Claims denied the protest because it found there was a lack of prejudice. It found that if the information that had been disclosed to some of the, but not all of the offerers, if that information had been disclosed to everyone, the Court of Federal Claims found, well, everyone's prices would have gone down proportionally, so the same 20 offerers would have received award. Well, we disagree with that. And we went to the Court of Appeals on that issue, that prejudice issue. And we felt good about that issue. We thought there was just a lack of understanding about how competitive procurement works. If 20 different offerers get 20 different pieces of information, they're not going to line up in the same exact priority in terms of award. So we felt good about it. We focused on prejudice. And unfortunately, the Court of Appeals for the Federal Circuit, after we filed our briefs, they scheduled oral argument. It gets canceled because COVID. We had oral argument scheduled in early April. It gets canceled. And they issue a decision on the briefs. So in June of 2020, the Federal Circuit issues a decision and says, we're going to vacate the award. We're going to vacate the we're going to vacate the Court of Federal Claims decision. However, we're still going to dismiss the protest. We're dismissing on timeliness grounds. And they invoke the blue and gold rule to say that Inserso should have filed its protest earlier. And the court points to the Court of Appeals points to 3 things. It says, Inserso knew that under the original solicitation terms that small business competitors could form teaming agreements with large businesses. True. They say the full and open competition had been completed in November of 2017. And the third thing, the Federal Circuit says, and Inserso was on notice based on FAR provisions about debriefings and notices of award that the agency here could disclose competitively sensitive pricing information to the full and open bidders at the time of and shortly after the notification of awards. So the Federal Circuit says, in SERSO, I connect those dots, those 3 dots, and based on that, find that you knew or should have known that the agency would disclose competitively sensitive information to some but not all offerors. So we'll go back to one of the first points I raised. Was that an extension of the blue and gold rule? The majority didn't think it was extending the rule. The majority cited several times to the terms of the solicitation and concluded that it was merely applying the existing rule. Judge Reyna disagreed. What he said was that the majority had improperly shoehorned Inserso's claims into the narrow and now undermined blue and gold domain. And he pointed out that the unequal disclosure of information occurred only because of the divergence of the schedule. So it wasn't that the original solicitation terms were flawed, he said. There's nothing in the original solicitation that was a patent defect. The only thing in the original solicitation that the court cites to is offers can team with whoever they want. Well, that's pretty much always the case. That's not a patent defect. The defect occurred because of what happened during the procurement. And so Judge Reyna says, well, the blue and gold rule focuses on, is there a defect in the terms of the solicitation? And by looking beyond the terms of the solicitation to what happened during the conduct of the procurement, the majority has expanded blue and gold beyond its original holding. So what is the impact of that practically? I think it means that for contractors that they have to protest whenever they think the rules of a procurement may have become unfair, not simply when they think the terms of the solicitation or the rules of the competition as originally issued are unfair. So personally, from a policy perspective, I don't have a problem with that rule. I think all of us as practitioners would advise our clients if they came to us and they said, hey, we think there's something going on with the procurement that's unfair. Here's what it is. It goes to the structure of the solicitation or it goes to the structure of the competition. We would say, yeah, you should file a protest. I think the difficulty with this case is that the court found that there was a patent error as opposed to a latent error. If it's patent, the onus is on the contractor to raise it in a protest prior to bid closing. If it's latent, then the burden is on the government to fix the problem. And here, it's the underlying issues were an organizational conflict of interest, unfair competitive advantage, and unequal treatment of offerors. And so to conclude, I think that those were patent based on connecting the dots from the solicitation's unremarkable terms to a contract award to the regulations was a tough decision. As Judge Reyna said, it places an undue and unjustified burden on contractors to actively investigate, anticipate, and preemptively challenge all conflicts of interest that could potentially arise under a solicitation. It's a tough burden, and I think it will result in some cases in a greater number of protests going forward. Now, what about the continued viability of blue and gold? In his dissent, Judge Reyna also concluded that the blue and gold rule runs afoul of a separation of powers principle that was articulated by the Supreme Court in 2017. Now, we didn't raise this argument. This is Judge Reyna sua sponte raising this issue at the Fed Circuit. And in that Supreme Court case, SCA Hygiene, the Supreme Court clarified that when Congress enacts a statute of limitations, it speaks directly to the issue of what is timely or not in that court. And the court does not have an ability to independently determine that a different time frame should apply. And so the Supreme Court stressed that courts are not at liberty to jettison Congress's judgment on the timeliness of suit, even if the court believes the statute of limitations gives rise to undesirable policy outcomes. And when you go back and you look at blue and gold, it's driven by policy. The court is saying we can't put up with protests that are filed well after, we can't put up with pre-award solicitation challenges filed after the award. Those need to come when the agency can take corrective action if necessary and deal with them. And that might be right from a policy point of view, but what Judge Reyna is saying is Supreme Court has issued this decision and it has said that the statute of limitations is the end of the inquiry in terms of whether an action within that court's jurisdiction is timely or not. So the future viability of blue and gold has been questioned. Inserso filed a petition for rehearing en banc to ask the entire court to hear that issue, and the court denied it without comment. So the viability and extent of the blue and gold rule going forward is at issue. It's going to come up in other cases. And here's one other case in which it came up. Harmonia Holdings Group. This was a case earlier in 2020, February of 2020. In this case, Harmonia filed a pre-award agency level protest, which was denied. And in that pre-award protest, it was challenging amendments to the solicitation. 5 months later, there's an award, and Harmonia files a post-award protest in the Court of Federal Claims, but it raises both its pre-award challenge to the solicitation and kind of routine post-award challenges. In February 2020, the Court of Federal Claims concluded that notwithstanding the timely pre-award protest, Harmonia nevertheless waived its right to its pre-award protest grounds by waiting 5 months to re-raise it at the court. So in essence, the Court of Federal Claims is saying not good enough to file an agency level protest. If you're going to bring that protest in this court, you either have to go to GAO or perhaps you have to need to come to this court and file that pre-award protest in this court. Now, what's interesting is the court found that Harmonia had facially met the requirements of blue and gold. So the judge says, okay, here's the blue and gold rule. They met that. They raised a challenge prior to the bid opening. But nonetheless, the policy rationale for blue and gold really prevents us from accepting this case, and the court found that it was time barred for that reason. Now that appeal is pending at the Federal Circuit, also up on appeal. It was argued in November. There should be a decision any day, really. And what we're going to see will be interesting because Judge Reyna is also on the panel of the Harmonia Holdings panel at the Fed Circuit. So it's possible that the viability of blue and gold will be revisited in the Harmonia case. And it's very important to stay tuned to that issue, to this issue, and to that decision for the balance of the year. And I know, Dan, you had a recent case, a blue and gold case that you wanted to talk about, the Perspective case. And,
yeah, it just came out, and it's a Sorry, it's an offshoot of the Federal Circuit's decision, and basically Judge Smith found that a conflict issue needs to be raised pre-award under the Blue and Gold Fleet doctrine, even if the government hadn't yet even considered the conflict or assessed its impact. So it really, to me, it eviscerates the whole concept of ripeness. I mean, it establishes a situation where an issue somehow can be waived before it's become ripe, which is obviously problematic. And I'm very hopeful that Judge Rainey will carry the day in the Harmonia decision.
Yeah, in the Inserso case, we made the same argument. It was not persuasive, although we didn't get a chance to fully brief the case like we would have if we had been focused on just blue and gold. We were really focused on prejudice. But in the Inserso case, the agency there didn't see the problem either. So there's an organizational conflict of interest, and it's the agency in the first instance that is charged with identifying and mitigating that conflict. And so we said, look, how could Inserso, a small business, have connected all these dots if the agency, who knew who the different offerers were and knew who was competing in the different suites, if they didn't connect the dots, why should that burden be on the contractor? So again, I think the finding that error was patent is the difficulty that I'm still having with that case. So,
Rich, thanks very much. Let me thank the panel for great insight, a little bid protest by fire hose treatment, I think, for today.